What is divorce mediation in New York? Divorce is often challenging, both emotionally and financially, but mediation can offer a path that reduces conflict, saves time, and promotes collaboration. Mediation is increasingly popular because it fosters open communication and fairness, creating a smoother experience for everyone involved, particularly when children are part of the equation. Here's how mediation can work for couples in New York. Legal perspective on divorce mediation in New York. Mediation is an alternative to the traditional court-based divorce process, allowing couples to work out their issues without going to court. Legally, it offers a flexible and private setting to resolve matters such as child custody, asset division, and spousal support, outside the public eye. Mediation is typically more affordable and faster than litigation, helping couples avoid drawn-out court proceedings. Importantly, agreements reached in mediation still require approval from a judge to be legally binding, so any final agreements will be part of the formal divorce record. One crucial role in mediation is the mediator's presence as a neutral facilitator. In New York, a mediator's task is to guide discussion without making decisions for the couple. While not a substitute for legal advice, mediators encourage open discussion, helping couples stay focused on solutions. Consulting a lawyer during mediation can ensure that your rights and interests are upheld as you work through the process. Key differences between mediation and litigation. Mediation and litigation represent two distinct approaches to divorce. Mediation is private, with sessions conducted in confidence and no public record of discussions. This is especially valued by couples wishing to keep details of their finances or parenting arrangements private. Litigation, by contrast, is public, often exposing sensitive information to a wider audience. Scheduling flexibility is another advantage. Mediation allows couples to choose times that work best for them, providing a more manageable pace compared to litigation's fixed court schedule, which can lead to delays and extra costs. Moreover, the decision-making power in mediation remains with the couple, ensuring that outcomes reflect their specific needs. In litigation, however, a judge decides the outcome based on legal guidelines, sometimes leaving both parties feeling unheard or unsatisfied. What is mediation in divorce? Divorce mediation is a structured process where couples work through issues with the help of a neutral third-party mediator, who facilitates but does not control discussions. In New York, mediation typically includes several steps. Initial consultation. The process begins with an orientation where the mediator explains procedures, confidentiality, and outlines the issues to be discussed, such as child custody, financial support, and asset division. Information gathering. Next, both spouses provide financial documents and other essential information. This step ensures transparency and equips each party with the information needed to make informed decisions. Defining priorities. Here, each party identifies their primary goals, such as fair co-parenting arrangements or a balanced division of property. The mediator encourages open expression of these priorities to set a positive tone for negotiations. Exploring options and negotiating. Finally, the mediator helps couples explore options that can meet both parties' needs, promoting creative solutions for things like parenting plans, spousal support, or property allocation. Agreements reached are often documented in a memorandum of understanding or marital settlement agreement for court approval. Understanding the mediation process. Mediation in New York is designed for flexibility and cooperation. Each step of the process builds upon the previous one to create an atmosphere of respect and productive discussion. The main stages typically include orientation, the first meeting where confidentiality and mediation roles are explained. Both parties set their goals for the process and clarify any specific concerns. Gathering financials. Essential to any settlement, each spouse discloses financial information, including bank accounts, property deeds, and liabilities. This transparency fosters trust and ensures that any final agreement is fair. Prioritizing needs. During this stage, both parties work to define and align on their main goals, whether financial, emotional, or practical. Final negotiation and agreement. After priorities are clarified, the mediator facilitates the final negotiations. Couples work together to reach an agreement on essential issues like child custody, alimony, and property division. When an agreement is reached, it is formally documented and can be submitted for court approval. When mediation might not be suitable, while mediation is beneficial for many, certain situations make it less ideal. Cases involving abuse or extreme power imbalances may not be suitable, as these factors can impede fair negotiation. Additionally, if one spouse is uncooperative or unwilling to compromise, mediation might break down, making litigation a better option. Mediation requires both parties to actively participate and negotiate in good faith to achieve a successful outcome. If you're considering divorce mediation, Juan Luciano Divorce Lawyer can guide you through this process, helping to protect your interests while supporting constructive negotiation. Contact us today at 212-537-5859 to schedule a consultation. Our office is located at 347 5th Avenue, STE 1003, New York, 10016, United States.